Hi, I'm Christina Jump, and I am the Constitutional Law Center for Muslim in America's Civil Litigation Department Head. Welcome to our presentation on denaturalization and passport revocation. And I'm also here today with Alyssa Morrison, who is our Civil Litigation Staff Attorney.
Hi, everybody. Good to be here as well.
And we are glad that you're joining us. Obviously, we are still sheltering at home, so we are in our homes, as you can see. But we are glad to be here presenting to you today and hopefully to give you a little bit more information about the denaturalization and passport revocation process and things to be aware of, as well as trends that we are seeing that are happening. So we've shared the screen with the presentation here. We'll flip back and forth between the presentation and when you can see us. And we'll go ahead and get right into it. One of the first things that we want to explain is what exactly is denaturalization. When we talk about denaturalization, it is undoing naturalization. It is really just the basic root of the word there. For those who get their citizenship as United States citizens through the naturalization process, there can be a denaturalization lawsuit, which is brought afterwards by the U.S. government. And it is the process by which the government tries to say that there was a problem with the citizenship and a reason to try to take it away or to say that it was invalid to begin with. And so that's what we're going to be discussing here today. Now, there is a distinction between those who get citizenship through that naturalization process, through the normal immigration channels, and those who have citizenship as birthright, meaning they were born in the United States, or because one of their parents is a United States citizen, or one of the other ways that birthright citizenship can be conveyed or bestowed upon individuals. And that we're not going to talk as much about birthright citizenship today. The denaturalization process and lawsuits apply far more to those who got citizenship through the naturalization process. We'll be focusing on that. I want to talk about the grounds on which this can occur so that you're aware of them. The main one, or one that comes up most often, is where the government claims that the individual got citizenship illegally, never should have had it in the first place, never met the requirements in the first place to get citizenship. Another is concealment of a material fact or willful misrepresentation. And what that means is that maybe you didn't directly lie, but you did not disclose something. This is what the government will argue, that you did not disclose something that you could have or should have at the time of the naturalization process. So you either deliberately hid it or you misrepresented it on purpose. This has to include, either way, a bad intent on the part of the individual, and that's what the government will need to show. Or within 5 years of becoming naturalized, you had an affiliation with a recognized terrorist group, the Communist Party, or another totalitarian entity. So basically anyone that the government considers to be on their bad guy list. And if within 5 years of naturalizing, even if everything was fine leading up to that, but within 5 years you join one of these entities and have an affiliation with them, then that can be a basis for ending the naturalization, revoking it. And also, finally, for those who obtain citizenship because of their service in the U.S. military, it is a shorter process than those going through the traditional immigration channels. And so if you obtain citizenship through the military service, but then are dishonorably or other than honorably discharged within 5 years after becoming naturalized, then that can be a reason to revoke citizenship as well. The concept there is that if you received your citizenship because of serving in the U.S. military, but then you do something that causes you to no longer serve in the U.S. military other than an honorable reason, then you've basically broken the bargain of what earned the citizenship in the first place. I think now Alyssa's going to talk to us a bit about the process of denaturalization. So Alyssa, go right ahead.
Okay, yeah. So what is the process of denaturalization? What is this going to look like procedurally? So first, the government has to provide 30 days notice of their intent to file a denaturalization suit. And what this is going to look like is a letter in the mail sent to your home letting you know that the government intends to file this lawsuit, and it will likely also contain the grounds upon which they're seeking to denaturalize you. And although this letter is not the lawsuit itself, that doesn't mean that you should wait until the lawsuit is filed to take action. As soon as you receive that letter, you really should reach out to an attorney and take those first steps to secure your rights. So then after that notice is sent to you, the suit will be filed, and you have 60 days to answer, meaning that you need to file an answer with the court within 60 days, either on your own behalf as a pro se litigant, or preferably with the help of an attorney. It's important to note that this suit is filed in a federal court, not in an immigration court, and that because this is a civil proceeding, you are not guaranteed an attorney like you would be in a criminal proceeding. You are certainly strongly encouraged to hire one, but unfortunately, the right to an attorney does not exist in the context of civil litigation. And so the government's burden here is clear and convincing evidence, and this is the highest standard that we have in civil litigation. It's very similar to the beyond a reasonable doubt standard that you've probably heard in the criminal context. So the government's burden here is high. And then very, very important is that if you don't answer the lawsuit, you will likely, if not certainly, lose your citizenship, because that will allow the government to win by default. Okay, so how will you know if you're being investigated for possible denaturalization? So one way is if a government agent, usually FBI, and quite possibly not somebody that you have encountered before or worked with through the naturalization proceeding, might approach you and start asking you questions that you had already answered during your initial naturalization proceeding. They might be asking you the same questions that you've already answered, asking them in different ways, asking about the circumstances surrounding your naturalization or things that have happened in the past. And this is a pretty good tip-off that the government is looking into reopening and reinvestigating your naturalization application. Another way is if you receive a notice in the mail telling you that they intend to file a lawsuit. If they send you this letter, they're going to file that lawsuit. And just to reiterate, this letter is only a notice. It's not the lawsuit itself, but it is still very, very important that you act as soon as you receive it. And then you will have 30-ish days until the government files that lawsuit. So like I said, the letter will say you won't need to do anything, and legally speaking, you don't need to do anything, as opposed to the lawsuit where you are obligated to answer within 60 days, but that doesn't mean that you should wait. Okay, and then once the lawsuit is filed, you'll be served with the lawsuit by a process server. So unlike the letter of intent, which you could potentially miss if you've moved recently and it's sent to the wrong address, or if someone throws it away by mistake, or you just don't check your mail regularly. So unlike that letter, the lawsuit, you will absolutely know that you have been served because somebody will serve you. Okay, so what are the consequences of denaturalization? So when you are denaturalized, if the government succeeds in its case against you, you will return to the status that you had prior to becoming a citizen. And unfortunately, this will likely result in deportation proceedings, because odds are if the government has gone through the trouble of reopening your case and looking into it and investigating you and taking you to court, they are probably seeking deportation. If you're denaturalized based on a criminal act, you may face jail time, meaning that you would serve your time in the US and then quite possibly seek or face deportation once you've served that sentence. And then another thing to keep in mind, although we're not going to go into it in depth today, is that your denaturalization can have potential consequences for your family members if they obtain their citizenship status based on yours. And it kind of depends on why your citizenship was revoked and the circumstances surrounding that, but that's just something to be aware of. So some specifics about denaturalization under the Trump administration. We all know that the Trump administration has not been an immigration-friendly presidency. And in February 2020, the Department of Justice announced the creation of a section dedicated to denaturalization cases. So this is a section that is completely dedicated to going back through already naturalized citizens' applications and looking for discrepancies and investigating that for the purpose of seeking denaturalization. And according to the New York Times, denaturalizations have ramped up under the Trump administration. There have been 228 denaturalization cases filed since 2008, and 40% of those, so almost half of them, have been filed since 2017. And in the past 3 years, denaturalization case referrals have gone up by 600%.
Thanks, Alyssa. And so I do want to continue so that we talk a bit more about this. As we mentioned earlier, and as Alyssa said, previously denaturalization proceedings were used very rarely, and they were used primarily for serious criminals, serious crimes that were committed. For example, war criminals in the years following World War II, or very clear cases of treason subsequent to somebody having been naturalized. We now, though, see the government using the denaturalization process on far less severe grounds than it ever has before. They have attempted to use this for minor errors in their applications for naturalization that may have occurred, or acts of dishonesty that may have previously not been considered serious enough for any investigation. So something that is very minor, even so far as some of the cases we've seen and some that we've handled for clients, traffic citations have been a reason that USCIS and that the government has actually acted to try to prevent citizenship or remove citizenship once it was already ordered on behalf of for an individual, simply because of not disclosing traffic tickets and not having any very serious crimes at all. We also do want to discuss the passport revocation here, and that is technically not as serious, but unfortunately it can end up having some of the same impacts that are just as serious as being denaturalized. And it's a much simpler and easier process on behalf of the government, so it's something that they're trying a lot. Revoking a passport document itself is much easier than the government winning a denaturalization lawsuit by the clear and convincing evidence standard that Alyssa described. There are several bases on which the government can revoke a passport. Most importantly, for our purposes, we'll talk about if the individual was never eligible to receive the passport in the first place. So what the government will state is that it never should have issued the passport originally to this individual. This individual never should have carried a United States passport, and there was either a mistake in the facts or a mistake in applying the law that governs at the time. The government must provide written notice to the individual, but this is a letter, not a lawsuit, of the intent to cancel the passport and provide the individual with a time to challenge this revocation. Now, unlike a denaturalization proceeding, where Alyssa described that you will receive a letter in advance if the government intends to do this, and then the government will file a lawsuit, it's just the letter for revoking a passport. There's no lawsuit that follows. If you do not respond to that letter, then the revocation becomes final. That's your one and only opportunity to challenge it. There will not be a hearing, there's not a trial, and there is no need for the government to provide proof of its position or why it believes that it has the right to revoke the passport document. As we said, it's not really just a document, and that's where this gets tricky. Possession of a U.S. passport acts as proof of United States citizenship. And under the law, cancellation of a passport technically only affects the document, not the underlying citizenship status. That is true, and that is why the government argues that this is an easier process. There's less burdens for it. It's not in government's statements. It is not as harmful. It's not as detrimental to the individual because they're only revoking a piece of paper. However, what we are seeing is that the government is beginning to use passport revocation as basically a side door or a shortcut to what they really want to do, which is cancel the citizenship. And with the passport revocation process, it's much faster, it's much easier, it's much simpler for the government, and chances are the government will never have to explain why in any proceeding, certainly not in any court most of the time. We are seeing the cancellation of the passport used as the means to invalidate citizenship as an effective matter without giving the individuals due process that they are guaranteed by the Constitution. And what the government argues is that the person was never really a birthright citizen if they're trying to revoke the passport of a birthright citizen, and that's where we do see this come in addition to those who are naturalized. I would say that in hindsight, this person was not in fact entitled to citizenship at the time that they were born. Therefore, we've gone back and revoked it. You no longer have a valid U.S. passport. Technically, again, all they've done is revoke the passport, the document. But they've done so by way of saying they've determined that you're no longer a citizen and that you never were. And you've now lost your proof of U.S. citizenship. So by revoking the document, the government has found a way to have the effect or the impact in many circumstances, in many settings, of having the same practical matter as revoking the citizenship itself. Some trends that we're seeing regarding passport revocation is that there is increased involvement from the passport offices. This has implications for citizenship as well as your ability to travel. The passport offices now are getting much more involved other than just processing paperwork. They're serving more as investigators, asking more questions. They're revoking passports of birthright citizens. That has happened with individuals who have been previously acknowledged to be birthright citizens, but the government has declared that that's not true by looking backwards, and they do this with no due process accompanying these loss of citizenship, particularly if the individuals do not know to challenge the letter that they received, to respond within the time set forth in the letter, which is very short, and to request a hearing and to follow up and make sure that they get a hearing, and then to potentially file a lawsuit if the government is not giving them that hearing. The government claims that its actions only affect the document of the passport, but that's wrong too. Much like Alyssa said, saying that you don't need to do anything when you first get that letter is, you're not legally required to do anything, but as a practical matter, you better start doing things right away. Saying that revoking a U.S. passport only revokes the document, again, it is a technical, legally accurate statement, but for all practical purposes, that's not true. It's going to have great impacts. It's going to affect a lot of parts of life. Denaturalization, we are seeing, is also being sought on grounds that previously would not have led to such severe action. Like we've said before, simple mistakes on naturalization paperwork, maybe getting the month or the year that somebody lived in a particular location off by a bit. Different understandings of terminology. For example, whether you're associated or affiliated with organizations. That's something that we've seen. Well, what does that mean? Does that mean that you held a role with the organization? Does that mean that you just were a member? Does that mean you attended events? Also, what is considered a citation? There's a question through the naturalization process that asks if individuals have ever been arrested, cited, or detained, and then talks about some reasons. Well, sometimes the government has argued that a traffic ticket counts as a citation, even if the individual was never arrested, never detained, and it was simply a low-level traffic ticket. That may be something that the government will try to then say, that was a citation, you should have disclosed that, and if you checked no on that box, but had traffic tickets, then they may move to denaturalization. We've also seen an increased review of previously approved naturalization applications. As Alyssa mentioned, there's been an entire government task force created that is dedicated specifically to going back over time. So the government already approved naturalization for citizens, already granted that. These people have already taken their citizenship oaths and they're acting as U.S. citizens, and the government's looking back over those files to see if there is a reason to second guess that decision. Revocation of the documents that prove the citizenship itself, again, seems to be a way that the government is moving to effectively revoke the citizenship, but with a lot less effort. The government doesn't need to do nearly as much to revoke the document. So what can you do to protect yourself here? First, be aware of your rights and know how you can protect yourself. Act immediately if you get one of these notices. Contact somebody who can help you. Don't just let it go. Don't hope it doesn't. Answer all questions during the naturalization process, if that's still happening, honestly and fully at the time. Disclosure of a fact, even if you think it might be bad or just not palatable, is way less likely to hurt you than if the government discovers it later and can try to use that to prove that there's something that you didn't disclose and should have. Even if it wasn't a big deal, wouldn't have changed the decision. The government may now, and has with many individuals, gone back and tried to show, see, they hid this. There must have been a reason why. Because they willfully concealed this, then that is something that we can use to show they shouldn't have become citizens in the first place. If you're not sure at all about how to respond to a particular question, please either consult an attorney, any attorney who is qualified in this area, or ask for clarification at the time, even from the immigration officer. And in these interviews, which are recorded, if the recording shows that you ask the immigration officer, what do you mean by that? I don't understand that term, or that's not a word that I use. Can you explain to me what that means? That goes a long way to show that you really were trying to answer accurately and thoroughly to the best of your knowledge. You were trying to be as forthcoming as you could. And if there was a misunderstanding, that maybe then in hindsight, it's not the impression that you were given at the time because you asked. Consult an attorney immediately. We do recommend during that initial window, if you get a letter saying that the government does intend to file a denaturalization lawsuit, or if you receive a letter saying that your passport has been revoked and giving you a brief window of time to challenge it. The initial window to answer either of those situations is crucial, and it can make a big difference between whether you are able to keep your citizenship or passport document or not. Failing to respond is going to very severely lower your chances for success ultimately. In addition to being up against the government and challenging the government's decision and the claim that they will make to a court that they are entitled to deference, it is also going to end up being something where you have to start by explaining to the court why you didn't answer in the first place, why it's okay that you're late getting to the starting gate, basically. And that's never a good situation to be in with the court. Here are some results that we have seen so far. Prolonged administrative processes, so where the government ignores its own timelines, doesn't respond back to the individual, possibly doesn't set hearings, doesn't turn over documents, things that the government is required to do but will at best drag its feet on, and in all likelihood try not to do at all. One of Alyssa's statements earlier represented the government proudly quoting that they win 95% of these. Well, that's because a lot of the times individuals don't know how to challenge them or don't have the resources or the knowledge to fight. So some of these are by default. Some of these are because the government just never turns over documents, and the individuals may not know that they have a right to that. They may not timely seek hearings, or if they seek a hearing, even if they get that far, the government never gets around to scheduling it, and the individual just doesn't know what's happening. So that's a large part of the reason for their quoted success, is just making the process as difficult as they can in many situations. The government is now going after people who at the relevant times were on the same side as the U.S. government. So maybe you have an affiliation with a group, with a foreign entity or foreign organization, that at the time that you had that affiliation, that you were a member of that group or worked with that group or even were just near that group or that entity, maybe that organization was working with the U.S. government, alongside the U.S. government at the time. But now, decades later, looking back on it, the U.S. government doesn't consider that entity to be good anymore. And so the U.S. government will look back and say, well, you know what? We don't like those guys. We don't think those guys are good guys anymore. And the fact that you were affiliated with someone we now consider to be not a good guy anymore and to be on the bad list means that we're going to look over everything again. And we've also seen the government have, this is one advantage, so we do have a little bit of positivity to give here, a sudden desire to negotiate. When a case gets to the discovery stage, when it reaches the level where the government is going to have to start justifying its positions, it's going to have to start answering questions, it's going to have to start providing documents and explaining its criteria. When we get to that point, not every time, but often what we see is the government so intent on not revealing this information that a lot of times they back off, or that's the time that we will get a phone call saying, let's see if we can work this out. Let's see what we can work out here. Let's see if we can resolve this some way other than us having to answer discovery. So that is one advantage that we do see through using the legal process in order to defend these rights. All right, that's what we have for you. That's a snapshot. We know it's a lot, but hopefully we have informed you more than we have scared you, or at least told you where to look for any red flags and to be concerned. We certainly can discuss more of this in detail or as it applies to any specific individual situations, one-on-one. You can contact us again through the Constitutional Law Center for Muslims in America. Our website address is CLCMA.org, so CLCMA.org. My name again is Christina Jump, and I am the Civil Litigation Department Head for the Constitutional Law Center for Muslims in America. And with me as well,
I'm Alyssa Morrison, a staff attorney in the Civil Litigation Department at the Constitutional Law Center. And we really appreciate you taking the time to listen to our presentation, and we hope that everyone is staying safe and healthy.
Absolutely. Thank you so much for joining us. We really appreciate it. We're glad that you could be with us today, and hopefully we'll be able to see some of you soon. Thank you.